Hello friends, welcome to Happy Institute YouTube channel. Happy Institute is one among the leading institutes imparting training in stenography. The institute in the last 35 years has helped hundreds of aspirants of government jobs in fulfilling their dreams. Students of this institute have secured top ranks in various All India competitive exams held by UPSC, SSC, DSSB, IBPS, and other recruitment agencies and are working in almost every department of Government of India, be it Ministry of External Affairs, Railway Board, Home Ministry, Election Commission of India, Income Tax Department, CBI, and other prestigious organizations like Supreme Court and High Court. We also publish happy speed dictations for developing speed with passages meticulously selected from latest topics with practical phrases and simpler outlines. This book has become the most prominent choice of almost every reputed institute, teacher, and student of stenography in a short span of time. The proof of its popularity is that in the last 3.5 years, more than 25,000 copies have been sold all over India. We have now launched a series of legal dictations to help aspirants who have to appear in skill test of Punjab and Haryana High Court on 27th February 2022. The dictation is released every day at 1 p.m. on Happy Institute YouTube channel. The students are requested to write and transcribe this dictation and compare with the original passage given in the description more than once if required. Please like and share every dictation that you write and subscribe to Happy Institute YouTube channel. Get ready for dictation, please. 5 seconds. Start. The learned single judge has also indicated that the sub-divisional magistrate, being an authority to correct the records, was within his jurisdiction to do so. We do not find this inference to be correct in as much as here the issue was the valid grant of lease and declaration of rights under section 131B and not a case instituted for correction of records. If the lease was an outcome of any fake or fraudulent transaction, then reversing it after 20 years did require the giving of at least a notice or opportunity to the petitioners who continuously stood recorded in the revenue records for 20 years. The state contends that the forms which were issued pursuant to the said resolution and approval do not bear the signatures of the competent authority. The order of the sub-divisional magistrate narrates the existence of 3 resolutions of the Gaon Sabha dated 18/5/1984, 16/6/1984, 16/7/1984. It is on the strength of these 3 resolutions that the sub-divisional magistrate has drawn an inference about the genuineness and validity of the proceedings of allotment. These 3 resolutions are stated to be existing in the report dated 11/5/2006, which in turn refers to 139 names that were recorded in the resolution dated 18/5/1984, but 140 people were indicated as eligible on the strength of preparation of Form 57 Kha. The second fact noted is that the allotment dated 16/6/1984 records 153 names after noting Form 57 Kha that are stated to be not available on the file. What is available is Form 58 Kha, but 146 of the same do not bear the signature of either the Lekhpal or village Pradhan. The resolution dated 16/7/1984 mentions 153 names that are recorded on 16/6/1984 but refers to Form Kha in favor of 198 persons. In our opinion, if the report indicates the existence of such resolutions, then the proceedings cannot be said to be fake. The proceedings can be wrong, irregular, or invalid, but they cannot be said to be fake. Secondly, the impugned order further records that the file appears to have been affected by termites and is also moistened by water. The top page of the file is unclear except the order of the sub-divisional magistrate and his signature to the effect approved as proposed. This endorsement has been treated to be doubtful in the impugned order by the sub-divisional magistrate, but there is no finding that the signatures are not that of the then sub-divisional magistrate who had approved the same. It has been abruptly concluded by the sub-divisional magistrate that since the aforesaid facts establish the proceedings to be doubtful, the proceedings dated 16/6/1984 and the approval order dated 2/7/1984 are fuzzy. We cannot approve of this abrupt conclusion as the file does exist. If the enquiry was proceeding about the genuineness of the very file itself and the proceedings, then the enquiry ought to have been made about the institution of the proceedings of approval by the sub-divisional magistrate on the resolution of the Gaon Sabha in 1984.